Welcome to Balanced Life with Debbie Carlin Boyle. Conversations connecting to a healthier you. The show that gives you all the latest and greatest health and wellness information to inspire you to live a life of balance and joy. Debbie Carlin Boyle is a health and nutrition coach, personal trainer, and fitness instructor who helps her clients live in balance with everything that feeds us, in addition to the food on our plate. Please welcome your host, Debbie Carlin Boyle.
Hello, good afternoon, everybody. Welcome to my show. This is Balanced Life with me, your host, Debbie Carlin Boyle, where conversations that hopefully connect to a healthier you. And as always, I'd like to get you connected with us. So having a live show here is very advantageous. And if you would like to become and get involved in our conversation today, I would like you to give us a call. And the number here is 323-843-2826. Or you could go to my Facebook page, which is Fit by Design, Balanced Life, but look it up under Fit by Design. And you will see us streaming live there as well. And you can make a comment or ask a question, and we will get back to you after the show. All right, important show today. And to start, I have a few statistics for you. So, according to a recent survey by Caring.com, only 42% of Americans have a will or a trust, and only 36% of Americans with minor children have a will or a trust. 47% of those without estate planning documents said they just hadn't gotten around to it yet. And 29% said it was because they didn't have enough assets to need one. One survey found that 32% of respondents would prefer to get a root canal or give up sex for a month rather than plan a will. So you see why we have a show. Conflict is a key word that comes to mind for me when talking about estate planning or lack of planning. I have seen over and over again what happens when an individual hasn't created a will or a trust, and the conflict which follows that literally tears families apart. My guest today, Marisha Charbonnet is an attorney with Family Security Law Group who is devoted to helping her clients craft innovative solutions to their unique family needs that deliver security and peace of mind. Marisha started her career as a litigator, and although she found it to be challenging and exciting, she found her role to be reactionary to something negative that had occurred to her clients. So with a desire to provide legal guidance that is both proactive and designed to avoid conflict, Marisha transitioned from litigation to estate planning. And I'm so glad to have her share with us today her expertise on how to navigate these issues that can literally make or break a family. Please welcome my guest, Marisha Charbonnet, to the show.
Thank you so much for having me.
Thank you. I'm sorry that I annihilated your name.
Oh, that's okay.
I have a reputation for doing that, and if I didn't do it, it wouldn't be my show. So there's my disclaimer. So welcome.
Thank you.
We met at a networking event, and I just cornered you and said, this is an issue.
It is.
I watched what my family went through when my mother didn't have a will or a trust. And then she was declared incompetent because she had dementia. And when that happened, there were four of us, and all, necks were getting twisted, and it didn't end well. And it took years, as you can imagine, because it went to probate. So I thought, wow, this is really taking years off of our lives, because the wellness factor in this is huge. The stress is huge, which in turn everything else goes downhill.
Absolutely.
So getting into it in the short time that we have, if you don't mind, I just want to hear a little bit about you and your background, where you grew up, and why you switched from litigation to estate planning.
That's a great question. So as you mentioned, I started my career as a litigator, and I did that for a long time. And as most litigators, if they're really being honest, I hated what I was doing. But I had a good job. I was on that wheel, and I just kept spinning.
Yeah.
Until one day, completely out of the blue, I got diagnosed with a very rare genetic condition that put me at an extremely high risk for developing cancer.
Oh,
And when I say high risk, I mean over 50%.
okay.
And at that point, I was 37 years old. I had a 1-year-old baby, married to the love of my life. And in an instant, everything changed.
Oh, I bet.
I suddenly found myself face to face with my own mortality.
Oh my gosh, you're so young.
Yeah. And I also found myself faced with a lot of decisions. My doctors were giving me options at that point, one of which was to undergo multiple risky, life-altering surgeries that came with no guarantees, but they could potentially reduce my risk. Or I could do nothing and kind of take the ostrich approach and just bury my head in the sand and hope that everything turned out okay.
Yeah, not really a good idea.
No. So after a lot of sleepless nights, I did go forward with surgeries, and knock on wood, everything's been good. But what I really learned from that experience was that
Life is short. Do what
life
you love.
is short, and as difficult as it can be to make certain decisions, it is far more difficult to be in a situation where you have no choices to make.
That's right.
And so, armed with that realization and a newfound appreciation for just how short life really is, I transitioned out of litigation and into estate planning, where I really see my role as being an advocate for decision making and a champion of choice.
Right.
My practice now is entirely devoted to educating and empowering my clients to make strategic, proactive decisions that have such a positive impact on their lives and the lives of their loved ones. And that is such a rewarding thing for me to be able to do.
Yeah, and I think this is so wonderful because I don't think, and we're going to get into this a little bit, I don't think people realize how empowering it is to have a plan.
Absolutely.
To be prepared and having the education and the know-how and then you just put that aside and go on with your life.
It is.
And what you're doing for your loved ones, aside from what you're doing for yourself in the here and now, is is remarkable. Is something that you can't put a price tag on that. You know. So, and that has to be satisfying for you and less stress filled than being a litigator.
Oh yeah.
In negative situations.
Absolutely.
Because that you absorb, I'm sure.
Definitely. And this is, as you mentioned, it is about being proactive.
Yeah.
And doing something to avoid conflict and to make life easier for the people you love. And that's a gift to those people.
Right, a gift, which is really important for people to understand. So why do you think? So let's it's something that people usually don't think of or do until they're way older. Right. So why do you think that is? What is?
I think there's a big misconception out there that creating a will or creating a trust is really something you only need to do if you're really old or really wealthy, neither of which are true. In the state of California, if a person's assets exceed $150,000, they're going to be heading down the road toward a probate unless they take some action.
Right.
And on the flip side of that as well, if you have minor children, you have an invaluable asset that needs to be protected regardless of how much money you might have in your bank account. And so those are two factors that really tend to go against that theory that, I don't need to worry about this until I'm a lot older.
Yeah. I think people worry when they have minor children, like if something happens to them, who will get the children?
Absolutely.
So, and I know for my ex-husband and I, when our kids were very small, we put that in writing so there wouldn't be infighting among the grandparents and the aunts and uncles and stuff. We were very specific about where we wanted them to go because we traveled a lot without our kids because of our work. But other than that, we didn't do anything else other than have like life insurance and beneficiaries. We just didn't think, well, we're a young couple, we don't have to. But it's really necessary, isn't it?
It is.
Yes. I didn't see that until everything started going down within my family, and I realized mad,
Absolutely. And that's one of the factors that tend to prompt people to do something, is because they go through a bad experience. They have to deal with a probate situation, and they actually get a firsthand experience as to what that looks like. Otherwise, it's very easy to see this as something that you're just going to get to.
So let's break it down then, so people are clear and educated about it, so they understand. So having a will or a trust, what is the difference?
That's a great question.
And then we'll talk about what probate is if you don't do that. Because
Sure.
I know all about that, and I know
Absolutely.
nobody wants to know about that.
And that's a great question. A will and a trust basically both serve to act as your instruction manual for what you want to have happen with your assets after you're gone. However, one of the key distinctions between a will and a trust is how they interact with the probate process. A big misconception out there is that many people think that if they have a will, they're not going to have to deal with probate. They're going to be able to bypass that. And unfortunately, that is not true.
Why so?
Well, because we come back to that $150,000 threshold that I mentioned. And if your assets exceed $150,000, if all you have is a will, you're still going to be going through probate. Now, the good thing about a will is that you at least are ensuring that your assets are going to be going to the people that you want them to go to.
Okay.
As opposed to if you die with nothing in place, it's going to be a judge making that decision who receives everything based on a hierarchy that the legislature has set.
Right. And it's a much longer process.
Definitely.
So how do you avoid probate altogether?
So that's a great question. So the legal loophole around probate is to create a trust.
Okay.
And I generally tell people to think about a trust as a box, okay, that you are building and custom designing to hold your assets. And it can hold anything. It can hold bank accounts, real estate, a business. But in order for this trust to actually protect your assets, you need to get them into the box. And the way that you do that is by changing title from your individual name to the name of your trust. So for example, if you own a home, you have the house, the deed is going to say that it is in your individual name.
Right.
When you create a trust, you're actually going to create a new deed that transfers title from you as an individual person to you as the trustee of your trust. That's the mechanism that gets it into the box.
Interesting.
And then what happens when you pass away, assuming you've done everything correctly and you've transferred your major assets into the trust, then when somebody goes to calculate what you have in your individual name for purposes of determining whether it's above or below that $150,000 threshold, you're going to be below it because your major assets are no longer going to be in your name. They're going to be in the name of your trust.
The name of the trust.
And that will allow you to bypass the probate process.
So if you know you have assets of $150,000 or above, a trust is the way to go.
Absolutely.
Do will and a trust go hand in hand? Can you have a will under a trust?
So that's a good question. Actually, when you create a trust, you also create a will, though it's a different type of will than what you would create without a trust. It's called a pour-over will. And it's basically meant to be a safety net document. And what it does is it directs that if there are any assets in your individual name at the time that you pass, that those assets are then to be poured into your trust after your death so that everything can be distributed according to the terms of your trust. So it's a way of ensuring that you have a uniform distribution of your assets.
Okay. So, all right. So that makes a lot of sense. So basically what we're talking here is going online to like LegalZoom.com won't really do it for you. You have to have everything really kind of tied up in a nice bow legally,
yeah,
right?
And I get that question all the time because obviously we live in a very
Quick,
yourself,
go online and
find the answer kind of society. But what you don't get with those types of document preparation services is legal advice. You're getting a document and you don't know if that document really contains the provisions that you need because you haven't had that conversation with a lawyer to actually tease out what the issues are. I'm always amazed when I talk with clients what kind of comes out of the woodwork half hour into the conversation.
Yeah, what they think they've done right or
And it requires that conversation to really figure out what needs to go into an individual's plan.
And unfortunately, I think there's a couple of things going down. One is people don't like to talk about death or their immortality or mortality, and they don't want to. So putting dots, periods and sentences to it, it's too finalized.
Sure.
I mean, the fact is, we're all going down that road. So this is preparation. And if you're prepared in life for anything and you have a schedule or you do an agenda or you have a calendar, it's really the same thing.
Absolutely.
It's being prepared. But people, the word death and dying and what do you call it when people get your assets when
an inheritance.
Inheritance, all those kinds of things are almost dirty words in our English language or universally dirty words because people don't want to think about
You're
that.
Right.
And so I think that's the one thing that's going on. And then the other thing is not realizing how intricate it should be, that if you just write on a piece of paper, is there any legal value if not even downloading a form, if you just write, this is my will and trust, I want so-and-so to get this, right. and that, even if you are over 150,000?
There can be, but I can tell you that the law makes it so complicated to have a valid document, which is why a lot of estates end up going through probate, even where people have handwritten wills, because maybe they didn't meet all of those technicalities. And how are they supposed to know what those technicalities are? In fact, just going back to something you said earlier about kind of the dirty word aspect of some of these issues, it's funny because, I think the reluctance, I always joke that the reluctance people have to talk with a lawyer about creating a will or a trust, I think is really only rivaled by the reluctance they have to talk with their kids about the birds and the bees.
Yeah.
So I just, let me set everybody's mind at ease. Talking about sex won't make you pregnant, and talking about death won't make you dead.
But I think that, I think you're right. Yeah. I think just the words alone are setting some kind of intention.
Sure. There's a stigma to it. Absolutely.
And I know when I was married, we didn't want to, like I said, all we did was make sure, and that is dealing with death, was we made sure who was, because we knew what we didn't want.
Right.
But I didn't see truly how things get very, very detailed and delineated, like you were saying, once a parent dies. Mm-hmm. And there's so many issues that go on. There's even infighting when you have everything buttoned up really nicely. Absolutely. Because somebody gets upset about what was willed to them that wasn't willed to, was willed to another and not them. And, there's all kinds of issues with that. But I think if parents actually talk to their beneficiaries about what it is that they're dividing ahead of time, they're doing a huge service to their children and their grandchildren or whoever's getting benefits of their inheritance. I think that's so important. But let's go back for 1 second and talk about probate.
Sure.
What it is, and because it keeps coming up that it's going to happen if you're not careful, and what happens and how it plays out and why.
So probate is essentially the court's supervised process for distributing a person's assets when they pass away. A lot of people are under the mistaken impression that when they die, their assets are just going to automatically get handed over to the people they want to have them. But unfortunately, if your assets include things like real estate or bank accounts or retirement accounts, it isn't always that easy. And so what happens oftentimes is then a court process is needed in order for those assets to get distributed.
And so an administrator needs to be court appointed. It could be somebody within the family, correct?
It could be. It could be if a person has a will, then they would have designated someone to act as the executor, which is basically the person handling the day-to-day administration.
Right.
But it's important to understand, too, that the probate is something that people generally really want to avoid for a couple of reasons. Number one, it tends to be very time-consuming. A quick probate...
4 years in my family.
Yeah, absolutely.
Yeah.
Because a quick probate takes 9 to 12 months. And that's where everybody's getting along. That's where the assets are all readily known and ascertainable. 9 to 12 months. And the assets are going to be tied up during that period of time until the court orders distribution. Now, probate also requires going to court, which stresses some people out.
Yes.
It can cause family conflicts.
Yes.
But probably one of the biggest reasons that people want to avoid probate is the expense.
Yeah.
With probate, the fees and costs are all set by statute, by the court. And the example I always give to people is if someone has an estate with a gross value of $1 million, which in California, you get to that number a lot faster than you think if you own real estate.
Yeah.
The attorney fees to probate that estate would be $23,000.
Oh, yeah, and that could be divided among the
Absolutely.
beneficiaries. Yeah.
And to add to that, the executor is always entitled to the same amount of money that the lawyer gets. So in that case, you'd be looking at a total of $46,000 just off the top for fees.
Yeah. And sometimes that's court appointed and not a family member.
Correct.
And if it is a family member, there's resentment among the other family
Absolutely.
members because they're not getting it. It's somehow, avoiding probate. So what we talked about at the top of the show, believe it or not, we're down to our last few minutes.
wow.
But what we talked about at the top of the show, the necessity to understand the process and stay away from probate at all costs are the most important thing we want to think about. So what is it? What is it that people should know and be doing today, right now, whether they're under $150,000 worth of assets or over? What should they be doing if they haven't done anything?
They should talk with a lawyer to
Okay.
figure out whether a will or a trust is the better option for them. Because the reality is everybody needs some type of plan. Because if you don't have a plan, the state has a default plan for you. It's the probate option. And the other thing that I always like to mention about this is that estate planning is not just about planning for your death. There is actually a benefit to you during your own lifetime by doing this. And that is in the event that you were to become incapacitated. Say you have a stroke or you get in a car accident, you're in a coma. Having an effective estate plan in place that includes powers of attorney and a trust allows you to have a designated agent to be able to make decisions for you in the event you can't make them for yourself.
Very important.
Absolutely.
And like I said at the top of the show, my mother she was diagnosed with dementia, and all bets were off because she had no will, no trust, and everything, infighting started.
Absolutely.
Because there was denial on my brother's side about her dementia, so he was trying to get her to sign power of attorney, which was illegal, and so we were calling him out on that.
Sure.
And then the caretaking, because my mom suddenly became incapacitated to deal with all of her own savings and issues.
Right.
So that's the reason why I'm doing the show, and also because so many of my friends, I'm in my 60s now, but my friends in their 40s, 50s, and 60s whose parents are elderly and things are starting to happen where dementia is starting to kick in, or their parents are hospital, in long-term care or whatever. There's stress in that in itself. But what I've noticed is the difference between less stress from those whose parents have already figured it out way in advance, and compared to those who have no idea what they should be doing for their parents or where they stand in the long run. And the kind of wear and tear that it's taking on them is a whole different kind of stress.
Absolutely. Because by creating a plan, it's a gift for your loved ones because it doesn't force them to be the decision maker. It puts them in the role of carrying out your choices, your decisions. And that takes an enormous burden off them because they're no longer having to guess, am I doing the right thing? They're simply doing what you've asked them to do.
Right. And that in itself can create calm. And when you see it in writing, the other siblings or whoever else is involved can see this is how the person wanted it, when they
Right.
were of sound mind. And then that's a whole other thing to diagnose sound mind. So in this last minute, before we get to final thoughts, let's talk about how people can get a hold of you in particular, or your firm,
Sure.
and what you suggest they should do.
Absolutely. You can always get a hold of me at my website, which is at familysecurity.lawgroup.com. We also have some upcoming estate planning seminars, which you can find on our website, to just get more general information about the process and how it works. But ultimately, I just really encourage your listeners, be proactive. Don't put it off. There is such peace of mind to having it completed and out of the way, and it takes a weight off your shoulders.
Yes, I absolutely, and everything that we've been talking about. And do you only deal with California residents, or can you help, because we're a national, international show?
Sure.
So
I am licensed in California, so I generally am working with California residents.
yeah, because laws are different in different states.
They are different, and
Yeah.
you're going to want to make sure that your estate plan is compliant with the laws of the state in which you live.
Okay. Makes sense. So much
Definitely.
sense. And we know how to reach you. Final words for my audience, leaving them. I think you've said you've given sound bites throughout the show, but what are some final thoughts you would like to leave my audience with?
Don't fear this. It is such an important process to go through, and there's such peace of mind at the end of the road. Don't fear it. Just be proactive, because it results in such positive outcomes.
I love that. That's great. I love it. I think it's very important to health and wellness. I really do. And I want to thank you, Marisha, for coming today. I finally get it. You got it. I got it. I want to thank you so much.
Thank you
Now,
for
if
having
you
me.
have a question for us, go to my Facebook page, To Fit by Design, make a comment, ask a question, and we can get back to you and keep the conversation going. So there you have it. I want to thank you for your time. I want to thank you for your time. And as always, I hope that you keep connecting to a healthier you. I'll be back next week. See you then. Bye, everybody.